Thank you for that warm introduction. It's a great pleasure and honor to be here, and Katja has also set the stage so well in giving you the background and the comparison between the US, the German, and the EU experience. So, confessions first, I'm not a banking lawyer. And I'm not a trained economist, although, the law and economics movement in the United States embraces lawyers as well as economists. I am a capital markets lawyer, and I come to the question of agency independence primarily from the perspective of the Securities and Exchange Commission. And one of the questions that has become particularly urgent in the United States, and this is kind of fortuitous because when we started talking about this conference, we had no idea that all of this was going to be on the table. But, one of the questions is, to what extent are independent agencies going to remain in U.S. law? And to the extent that the independent agency is on the decline, and I'll give you some of the reasons, some of the factors that might play into that, is the Federal Reserve different, either legally, structurally, or functionally, right? And on that latter issue, I can raise some questions. I'm hoping the more expert participants in this conference will help provide some answers. The other reason I think that the general question of agency independence is important is Katja and I spent the last 2 days working with students on the broader question of agency independence, and it really brought home the fact that Germany versus the EU versus the United States have very different ideas about what agencies should be independent, what are the concerns that independence is designed to deal with, and how you legally structure independence. So what do we mean by independence? What do we do to put it in place? Right? But let me start by placing agency independence in the United States a little bit in historical context, right? So that's the court-packing threat that largely led to the New Deal settlement and the rise of what we might call the administrative state in the United States, right? So what was going on? There were, prior to FDR, prior to the New Deal, there were administrative agencies in the United States, and I'm going to be a little bit lax here because we're sort of limited in time, right? Independent agencies, executive branch agencies. We had a host of different agencies. Each agency has a unique statutory mandate. There are differences in agency structure, and there are differences in the components of independence, whether it's the responsibility of an agency to take direction, whether it's the composition of the heads, whether it's their appointment or removal process, whether it's financial independence, right? So, when we talk about the independent agency, we are, that's within sort of a broad umbrella of both independence and functions, right? But we had, in response largely to the Great Depression, but also industrialization, there was a demand for greater regulation. And in the context of the New Deal settlement, independence meant largely independence from industry pressure. So this idea of political interference was only part of the issue, right? And the independence from political pressure was in part a concern that if all of this regulation was at the behest of, say, the executive, that would be, one, too great a concentration of power, and that would be a concentration of power that was coupled with a degree of political instability, right? And the idea was, well, we can address this to the extent that there are areas in which regulation isn't and shouldn't be about politics, right? So capital market regulation, competition law might be grounded in scientific, in technical principles. There might be clear right or wrong answers, and it could be the case that that technical expertise also doesn't fit well with the characteristics that tend to dominate in politicians, right? So let's have some sort of separation, right? And that's the New Deal compromise, right? And so the basic idea is, that these things are fairly complex. They require specialized knowledge. In order to turn that specialized knowledge into policy, you also need a degree of insulation from the political process, and the additional advantages that agencies offer include responsiveness, flexibility, speed, right? It's a different way of regulating, right? So, at the time, right, the idea that the industry knowledge can allow an agency to shift as demands, as new developments, because this was an era in which we had a lot of new developments, as they demand, right? Joel Seligman says, only with independence can regulatory agencies perform this function. And as Justice Elena Kagan said, we can only justify this insulation, this bureaucratic power, based on this specialized knowledge, based on this expertise, right? So foundational to the New Deal settlement are expertise, are specialization, and as a result, bureaucratic insulation. But it doesn't last. In fact, it starts to break down almost immediately. Right? So the first step in the breakdown is, and I was, when I was learning more about the German Constitution, right, the demand for democratic accountability. No, we don't want pointy-headed bureaucrats, no matter how smart they are, insulated. So the Administrative Procedure Act, the idea of notice and comment, you need these experts to listen to both the regulated entities and the general public. Well, if they're so expert, why are they supposed to make policy based on what the general public thinks, right? An inherent tension there. The idea of more aggressive judicial review, and limits on agency power, right? All of these are constraints. All of these are an almost immediate pushback from the New Deal settlement, right? Now, in the last 5, 10, 15 years, the pushback has increased, right? And some of this is stuff that's already happened. Some of this is stuff that's ongoing or sort of the possibility in the future, reconsidering the scope to which Congress can delegate rulemaking authority to an administrative agency, right? The non-delegation doctrine, that's up in the air right now. Chevron deference, right? That's gone, right? But a host of different areas in which we say, too much concentration of power, too much power that is removed from democratic oversight, that's a problem, and these are ways in which we can cut back, right? So you might ask, why do we see this? Why did we see this starting in the 1940s? Why do we see this even more today, right? And several possibilities, right? So maybe from a matter of constitutional law, from a legal perspective, the court just got it wrong, right? They were pressured by the court packing plan. They were pressured by FDR, right? So they succumbed, and it kind of raises interesting questions about independence of the judiciary, right? Response to political pressure. So even the most protected lawmaker may also be subject to political influence. But maybe they got it wrong. Maybe from a constitutional perspective, this idea of independence just never made sense. Maybe agencies were just making too many rules, and this was a bad thing, and this is a way of deregulating, right? Katja's already talked about the unitary executive. This could be something that is specific to President Trump, right? Or maybe there are developments in the way agencies work that weren't consistent with what everybody expected at the time that we accepted the administrative state. Right? And so I want to flag just a few of these and ask you to think about the extent to which they apply to specific agencies that you're familiar with, and to the extent they do, whether central banks are in some way different. Right? So first of all, and again, Katja said, the administrative state has grown. We've got way more agencies. We've got agencies, the EU continues to sort of create new agencies. The scope of administrative regulation has extended, right? So they reach today almost every aspect of daily life. It's not, they're sort of the specialized, the hyper-technical, they're everywhere. And therefore, right, if we think about the evolution, things don't look quite the same as they did at the time of the New Deal, right? Second, independence has declined, right? So it's declined in part in the US because of Congress. Congress cut back. Congress said to agencies, you have to listen to the public, you have to be more accountable. If you think about things like agencies submitting their rules for cost-benefit analysis and approval, if you think about the Sunshine Act, right, all of these things are reducing insulation, right? And the Supreme Court, of course, is considering further declines to the extent that it accepts broader presidential removal power. The confirmation process. So I think it's kind of funny, and I'll talk about this a little bit more, that we make such a strong distinction between appointment and removal. And if you look at the appointment process in the United States, it's gotten tremendously political, right? And there are people who are not confirmed, whose nominations are withdrawn, sometimes based on the pressure of their own political parties, because they hold views, that policy disagreements between those nominees and members of the Senate, right? And of course, there are other forms of political branch pressure. And we see that politics playing a role in agency decisions. We see less consensus, we see more split decisions, we see agency rules flip-flopping and agency adopting and then abandoning a rule when there's a change in the administration, and tremendous power in these multi-member agencies of the chair, who of course is aligned with the political party of the president, right? So all of that's happened, and you can trace the development, and I do in my article of a few years ago, with respect to the SEC. Now, I would argue that expertise has also declined. And again, right, I'm painting with a broad brush. You might say, oh, that's not true for central banks, right? Yes, your SEC, they're different, right? But you know, many times you have political staffers, you have politicians, you have people who what they bring to the agency is their connection to the political branches. And in fact, we seem to like that. In the United States, we worry that people who are deeply enmeshed in industry, right, that's a conflict of interest. Sure, they're knowledgeable, but yeah, then they might bow to industry pressure. They're not sufficiently independent. It's a conflict of interest. We don't really want them, right? We also see in many cases rulemaking that relies less on science, on expertise, and more on political pressure. And we see agencies that in many cases, because of these factors, don't respond in the way that the defenders of the New Deal settlement thought they would. They are left kind of flat-footed, emerging trends, right? And it's interesting, I was at a conference just last week on the crypto industry. And, you might say that that's a nice example. There are some areas where, both the SEC and the CFTC have been caught kind of flat-footed because they don't really understand the market developments, right? And of course, talk about not particularly responsive. Our keynote speaker mentioned climate risk. The SEC went through this long, unwieldy process to try to deal with climate risk through a disclosure rule. Right? They spent years, the rule's 886 pages. It was immediately challenged in court. It's obviously pretty much dead. That's not the kind of nimble responsiveness we would hope for from an agency. The idea that you need an omnibus rule as opposed to an incremental approach, that's also sort of crippled some of what agencies can do, right? So in my paper, and I'm not going to go into too much detail here, I talk about things that are really specific to the SEC. How could we tinker with things? How could we enhance agency independence? Of course, that's not the only option. The other option is to say, you know, this was a mistake. Let's get rid of it. So my frequent co-author, Adam Pritchard, wrote 20 years ago, he said, you know, let's just take the SEC, let's forget about independence. It was a bad idea. Fold them into the executive branch. Ironically, just last week, Adam started a position at the SEC. Let me now shift this so that there's some closer tie to what's going on in the US right now, right? So one question is removal. To the extent, and I said we've got all of these different statutes, the president's removal power arguably varies depending on the nature of the standard. But you know, some statutes say removal only for cause. We see that in the Federal Reserve Act. Well, what exactly is cause? What does that mean? Right? The questioning in the Lisa Cook case is all about, well, let's assume the president's allegations are true. Does that meet the statutory standard? Right? Is that language for cause removal different from the language in some other statutes that seems to be possibly narrower, possibly more focused on misconduct in office? Right? To the extent that we have statutory limits on removal power, is this even constitutional? So Katja mentioned Humphrey's executor. It seems quite likely that this Supreme Court, again, thinking about judicial independence, that this Supreme Court will decide, no, Congress can't actually limit the president's removal power, right? And as I said, is removal power really a core tenet of agency independence, given the other types of independence, the other factors that we've talked about, right? And so the question that you're all asking yourself, because you're all banking lawyers or bankers, is, well, but what about the Federal Reserve? Is the Federal Reserve different, right? And there's a suggestion that it is. So there's this cryptic footnote in a prior Supreme Court case that talks about the Federal Reserve as a unique institution with a unique historical background. I don't know what that means. Unique institution because it's got a different structure. So 14-year terms, pretty long, right? That seems to be a desire for insulation. Appointment only comes up every 2 years. So to the extent that I said, well, appointment power and removal power are kind of similar, right? Any given president is going to be limited in the number of people that he or someday she could put on the Federal Reserve Board of Governors. Historical background, I don't know. What about functional background? So again, our keynote speaker talked about monetary policy, interest rates, kind of the core of a justification for central bank independence. But central banks and the Federal Reserve, in particular, do a lot of different things. How much of that is integral to the idea of independence and would justify or would require separate treatment? Or do we sort of split that off and say, well, you can only have insulation if your functions are more limited, if your functions are less political, right? So, and that's, of course, Lisa Cook and the Lisa Cook case, right? So, just a couple more things that I want to flag. Obviously, we've had, just in the last week, a nice illustration of the politics involved in the appointment process as opposed to the removal process. But there are lots of ways that the composition of an agency, the heading of an agency, can be affected that are actually separate from both removal and appointment. For example, right, we've got a lot of agencies now where the president just hasn't appointed the full slate of commissioners. So does it matter whether the president has the power to remove, say, this president, a Democratic commissioner, or just not appoint one? And you've got a commission that's supposedly bipartisan, that is staffed solely by Republicans. right? Is that really different? And that seems to be, an independent concern, right? And of course, that can also cause regulatory failures, right? To what extent is a commission that's not fully staffed capable of effective action? And finally, there are other forms of pressure, right? So Jerome Powell, the subject now of a criminal investigation. When you think about, and I again was thinking about our keynote speaker's concerns about political pressure, surely the threat of execution is kind of the most extreme threat. But if I'm sort of worried about political influence, is the threat of a criminal prosecution scarier than the threat of removal? I don't really know. But yeah, so that's really, I've gone on too long, but that's sort of my both US perspective and broader agency perspective, and hopefully I've given you some fodder to tie this more to central banks. Thank you.